of those issues, an international platform dedicated to that, is also being bypassed. It gives you really an idea of how far those people want to go. And so, as of the 3rd of December, the final version of the text has been published. It is final. There's no way that we can change a word in what is ACTA at this stage. And now for the boring part. So, the boring part. What is really in ACTA? You will read. This is the Article 23. About the criminal offenses. Each party shall provide for criminal procedures and penalties to be applied at least in cases of willful trademark counterfeiting or copyright or related rights piracy, whatever that means, on a commercial scale. And also those criminal procedures and penalties, the signatories of ACTA shall ensure that criminal liability for aiding and abetting is available under its law. Now look at this. Criminal procedure and penalties for piracy, whatever that means, on a commercial scale. And then you ask yourself, what is a commercial scale? That's a very good question. This bit was purposefully left vague as you see it. So it is completely open to interpretation at this stage. Anyone can come and say, oh look, 1 million people sharing one file. It's a commercial scale. Indeed. So you get rid of the commercial intent. That would be the only way to limit what is acceptable and what is not. If you want to make business out of making copies, then okay, I'm okay. It's infringement. So instead of the intent, we consider here the commercial scale. So the industries can hire lawyers, make them work on making anything fit into that notion of commercial scale. Also, you notice criminal liability for aiding and abetting. Aiding and abetting? Seriously? This, again, is so vague. Am I doing this noise? Me? Oh, how? This notion of aiding and abetting is so vague that you can make anything fit into it. Think internet service provider. Think internet access provider. Think any kind of online platform, any kind of technology. Of course, you make a BitTorrent client. Indeed, you're inciting, you're aiding and abetting, of course, for infringement. So basically, this tool is a kind of atom bomb pointed to anyone we would want to make comply. And comply with what? Well, that's the rest of the agreement for more boring part. The Article 27 is called enforcement in a digital environment. Here you read, blah, blah, blah. Each party shall ensure the enforcement procedure are available under its law so as to permit effective action against an act of infringement of intellectual property rights which take place in the digital environment, including expeditious remedies to prevent infringement and remedies which constitute a deterrent to further infringements. And then ask yourself, once again with your hacker's mind, what is preventing infringement in the digital environment, if not filtering, blocking of access, restriction of access? What else could it be? Now ask yourself, what is a deterrent to further infringement? I won't go up to science fiction movie plots where cops act on the future, you know? But deterrent to further infringement? Here again, as far as you can think, you will only see filtering, blocking, and restrictions of access. If you continue the reading, you'll see, well, it looks quite harmless. Each party shall endeavor to promote cooperative efforts within the business community to effectively address blah, blah, blah infringement. Well, those cooperative efforts we're quite familiar with at this stage. We are familiar with them because it's approximately the wording that is in the Digital Economy Act in the UK. It is approximately the words used by the European Commission in its own communications about IPR infringement. And when they talk about cooperative efforts, it means that the rights holders and the internet service and access providers will work together. It means literally that internet service providers will have to obey to the rights holders to find common agreements. Yes, then what it means? is that there is no judicial authority anymore here. This is exactly how you bypass judicial authority. So, on top of the private copyright police, of the entertainment industries surveilling the networks, collecting IP addresses, with this mechanism, you add a private copyright justice on the internet. You make sure that the internet service providers, that any actor online will have enough legal pressure with the commercial scale, criminal sanction, and so on. So when the rights holders will come and say, oh, now you will cooperate, or else, well, you get sure that now they will comply. So it is literally a framework to ensure that the signatories of ACTA will be able to deploy schemes such as the Digital Economy Act, such as the Adopi, and such as more evolved schemes that will indeed include filtering of the net. You all know that first they come with the child porn and impose the filtering of the net, and then they can use it for other purposes. The recording and movie industry have been requesting filtering of the net for years. In France, President Sarkozy, in his New Year's wishes to the world of culture, literally said, if Adopi is not enough, we will need to go further, and for this, we will experiment with no delay filtering schemes. He said it already. He literally already promised it to the very same entertainment industries that got the Adopi. So, with ACTA, you got a framework ready to deploy on a massive scale those schemes. And now you think, okay, no, this is one extra bit. It's a special thread for German people keen on privacy. A party may provide, in accordance with its laws and regulations, its competent authorities with the authority to order an online service provider to disclose expeditiously to a right holder information sufficient to identify a subscriber whose account was allegedly used for infringement. How do you like it? So, signatories of ACTA will make sure that the rights holders can directly get personal data about alleged infringers. Alleged, which means not going through a judge, not going through the judicial authority. Seriously? My personal data? Okay, so the most twisted minds among you, or the lawyers, will have noticed that this begins with a may. And so when we go into the European Parliament or to the institutions to rant about that, they say, oh, but don't worry, there's a may. A may means it's not mandatory. A party may provide. They may or they may not. So it's all right. Don't worry. Well, actually we do worry. We do worry because this sets a precedent. This is a strong political move if the countries sign for this, that they find it acceptable. And further, this is the icing on the cake. Further, in ACTA, you have an Article 42 that is part of a section called Institutional Agreements, where those guys are creating with ACTA an ACTA committee that will be able to review amendments. So once the ACTA will be signed, they can just gather again and say, oh, let's change this word. Oh, yeah, my dear friends, let's do that. So a may you read here could further become a shall, a must. And this is also something of great concern. Because if we accept the creation of ACTA with its ACTA committee able to make amendments, it means that we create a durable, parallel legislative process, well, non-legislative process, that will deal with the internet infrastructure with a direct impact on our freedom of speech, on our privacy, and on our fundamental right to a fair trial. And now you think, yes. So ACTA is an atom bomb to our fundamental freedoms and to the internet. So now you think, maybe, what shall we do? What can we do? Where can we put pressure? How can we make this to stop? Well, at this stage, there is only one answer: the European Parliament. Whether you like it or not, it's the only democratic institution in the European Union. It's the only one on which we can have a weight. In ACTA, the EU, we are all represented by the Commission. The Commission are unelected fonctionnaires, are the administrative body of the EU. So they are dealing with most of ACTA because they're in charge of the trade agreements. But as I told you, ACTA is much more than a trade agreement because it has criminal sanctions. And criminal sanctions are usually in the sovereignty of the member states. Well, now the European Parliament has its way to change the criminal law of the member states. But so far, before the Lisbon Treaty, it has been in the hands of the member states. Therefore, along with the Commission, and I'm sorry if I bore you with that, but along with the Commission on the negotiation table of ACTA is also the presidency of the Council of EU that represent the governments. So it's literally the governments dealing with new criminal sanctions outside of any democratic process with the European Commission. So we have to attack their legitimacy to deal with our fundamental freedoms without a proper democratic debate. And the only place to do that is the European Parliament. We had several victories in the past in the European Parliament. You remember the software patents fight. You remember the telecoms package where we kicked out Adobe-like schemes in first reading and got all the members to get really concerned about, citizen rights and freedom and so on. We scored also about net neutrality, making sure that this notion will be not understood but at least taken care of. We made net neutrality to become a real issue in the telecoms package. We managed to kick out some initiative reports and win on some minor votes along the time. So you must keep that in mind, that we can win in the European Parliament. And as for every campaign, as for every action, the probability of having a positive outcome is directly proportional to the energy we invest into it. This is why I'm here, and this is why I need you to take care about that. This is why we all need to take care about that. Because since the Lisbon Treaty, the European Parliament will now have one occasion to say its word on ACTA. It's a vote by yes or no. So you may think it's not enough for democracy, and I will agree, but that's where we are now. There will be a vote in that procedure called of consent, where the European Parliament will have to say yes or no to ACTA. And this is the next and final step on which we have an occasion, all of us, to wait in and make sure that our elected representatives will do their job of protecting our fundamental freedoms. They will work within their political groups, they will talk to their colleagues, and if we do that properly, if we raise enough energy, if we make enough noise all over the internet about this vote and these stakes, ultimately we have a chance to win. So I ask you here, very solemnly, to be aware of that, be careful about that, and help us play a part, and play a decisive part into defeating the motherfucker. Okay, I take this as a yes. Okay, so more importantly, there are other issues that will be coming in the European Parliament in the next months, in the next years. You've all heard of IPRED. You've heard of IPRED 2. So IPRED 2 was set in the freezer, then will come back like in a bad horror movie. It's about new criminal sanctions for copyright once again. There is also the e-commerce directive that may be modified soon in the European Parliament. In the e-commerce directive, you get sure that internet service providers are not held liable for the actions of their users. But of course, that's what the entertainment industries want. So they will try to change it.